Thank you for watching the Housing Oregon YouTube channel. Be sure to join our network and get involved in the work that we are doing. If you can, please like and subscribe. It helps us build this channel, which serves as a platform to communicate with our members. This video is part of our 2025 annual conference. We're looking for folks to be on the conference planning committee. Please email info@housingoregon.org.
All right. Can everyone hear me? Yeah, I think so. Okay. Hi, everyone. Welcome to our Fair Housing for All Act workshop on SB 599. Thank you so much for sticking around on the third day, the last workshop block, to know about how we can protect immigrant and refugee rights in Oregon and their access to housing. I'll introduce ourselves and who's going to be presenting today and just kind of give an overview of what we're going to get into. My name's Henna Alsgal. I am the Housing and Community Safety Policy Coordinator with Unite Oregon. And Unite Oregon is a statewide immigrant and refugee rights organization that mobilizes, educates our immigrant and refugee communities across the state to fight for their rights in issues such as housing, education, climate, and economics, to build a truly inclusive Oregon for all. And I'll pass it on to my co-presenter, Sybil Hebb.
Hi, everybody. Thank you so much for taking time to join us today. My name is Sybil Hebb. I am a policy advocate, which is another way of saying lobbyist. And I'm trying to train myself to say the word lobbyist because that's what I am. And but I'm a public interest lobbyist, so I'm trying to get more confident about that. Anyway, I work for the Oregon Law Center, which is a legal aid provider, and we have offices that serve every county in the state. We provide free legal assistance to low-income Oregonians in civil cases, and a lot of our cases involve housing justice, tenant protections, and housing stability cases. So that's what brings me to the issue, and it was a great privilege to get to work with Henna in passing this bill and many, many others in passing this bill in the 2025 legislative session.
So for today, we're going to go into what is SB 599, right? And what this bill will mean for our immigrant and refugee communities in housing, and what is essentially going to be, what is the role of organizations that work with tenants, what is the role of housing providers, into making sure that this is enforced and implemented, and how can we understand it in this also greater context of ICE right now, kind of in the context of mass expansion of ICE.
One quick disclaimer is just to make sure that everybody understands that what we're talking about today is not specific legal advice, it's information, and we are all happy to answer further questions in more detail down the line, but that's the disclaimer I'm required to make. So, thanks.
So about SB 599 and how it came to be, I can at least speak a little bit and storytell from Unite Oregon's perspective. But as Sybil mentioned, this was passed during the last legislative session through the Stable Homes Coalition, which is a broad and intersectional movement of legal service providers, immigrant and refugee orgs, tenant advocacy organizations who kind of came together and realized within all the movements and communities that we work with, there's a direct intersection between immigrant justice and housing justice. And so within Unite Oregon specifically, as I mentioned, we are statewide. We have a chapter out in the Rogue Valley, and post the 2020 fires, actually, the one that Representative Marsh was speaking about, many of our communities lost their housing, and with the limited supply that was now existing there, many of our immigrant and refugee communities were actually struggling more than others to access new housing, and specifically based on the precedent that they were getting asked, what is your immigration status? What is your social security number? Can you show proof of citizenship? And which we realized there is no reason, no rhyme, no rhythm into knowing someone's citizenship status in order for them to be a viable tenant or to continue existing and having their housing. I know also, Sybil, you can share a little bit about what this covers that is not previously covered.
Thanks so much. So one, to echo Henna's testimony about the stories that Unite was hearing from community when Henna and Unite brought this up to us, and we're very grateful that they had such a window into the experiences that people were having. when we heard about those experiences, they echoed stories that we had heard over the years, and we had not been in as direct contact with as many people who were having the problem as Unite and Hannah and her colleagues were, but the stories echoed a couple of different examples that we had seen in our casework, and so we were very interested in figuring out what we could do to help. And so just an example of a case or a type of case, anonymized of course, that we had seen through legal aid was a person coming forward saying that they had been retaliated against because they had asked for repairs, and they were worried, or their landlord had responded in a way that of course none of us would espouse, but that was threatening to interface with ICE and to try to get the tenant to be quiet. And we were examining this case and these facts and asking ourselves, isn't this already a violation of Oregon's Fair Housing Act, which, as you probably know, prohibits discrimination on the basis of national origin, as well as race and many other protected classes. And we argued, in this case, immigration status is being used as a proxy for race or as a proxy for citizenship, and for national origin. And we tried to make those arguments, and we were unsuccessful in doing that. And so that said to us, there's a hole here. This is the same kind of behavior that the Fair Housing Act is intended to protect against. We know that good, well-trained and good-hearted landlords who are intending to be in compliance with the Fair Housing Act are already including immigration status in their category of cases and circumstances in which they would not ever discriminate. But here are some outlier examples, and it's a gap in the law. We weren't able to provide the protection that we wanted. There were times when we were successful in making those arguments, but it was a situation in which we would have to say to our client, we don't know what's going to happen, and it's up to you to decide, do you want to take this risk or not? And increasingly in this housing market, as we all know, it's harder and harder to take risks, and that's not an appropriate. We don't want people in that situation, and we think it undermines the intent behind the Fair Housing Act, which we all appreciate and embrace. So this was a welcome opportunity for us to close that gap and to try to implement the intent behind the Fair Housing Act. The other thing I'll just quickly cover that we recognized that the city of Portland had an ordinance that was designed to get at some of this behavior that's been in effect since 2019. And so we used that, and the city of Portland was super helpful, which we appreciate. And we used that language as a model. And we also looked to see what other states have addressed this issue. And there were 5 other states that had done that. Most recently, Colorado passed a law in 2024. And so we said to ourselves, look, this is doable, this is important, and let's get it done. That's.
Yeah, thanks, Sybil. And so I know, as we said, like this was immigration status is not previously, it's not included a classification within currently Oregon's fair housing laws. So the way that this bill specifically looks to codify immigration status as a protected class was including it in Oregon's Landlord Tenant Act. So specifically including that as a protected category of folks and being able to access housing. And the way it specifically does that in 3 ways. And so it protects tenants, potential tenants or current tenants from being asked about their immigration status. So there is no reason that a landlord should be inquiring about someone's immigration status. And I know Sybil will also kind of cover where are the exceptions in that. But overall, generally there should not be a standard where they are asked. And that includes, of course, more intimately, that a landlord may not discriminate against a tenant or a potential prospective tenant. And I should include that also means members of their households that are living and residing in the area as well, or in the unit. And that the landlord must be able to accept other forms of identification other than social security number or any kind of proof of citizenship. And so in the next slide, we actually include, these are different examples. I think it's non-exhaustive in my understanding in terms of what are the different forms of identification that can be paired up together to prove someone's date of birth, their name, and their physical appearance. The whole point and basis of that is that the landlord, with very few exceptions, should not be able to, does not need to have a tenant's immigration status on file or in their information in order to be able to rent out to them.
Thanks so much, Hannah. And I'll just add two things that when we've become very used to referring to this as a bill that addresses immigration status, which it does, and that was really the underlying driving purpose of the bill. But I have to always remind myself and work to put it back into the summaries that it also covers discrimination on the basis of citizenship status. So, for example, you can't ask, are you Ukrainian or are you Russian or are you, whatever your citizenships. That's not a permissible level of inquiry, and that probably has less been a gap because that is more closely connected to national origin. It's easier to argue that that is already very explicitly covered in the Act, but we wanted to just add that explicit coverage as well. The other thing, as Hannah mentioned, there are exceptions to these three forms of protection that the bill provides, which are specifically in cases where federal law preempts the state from addressing this. So, for example, federal subsidized housing providers are required as a condition of eligibility in some circumstances to only offer housing to people of certain immigration statuses or citizenship statuses. And in those circumstances, those providers are allowed to ask questions and are allowed to require certain forms, for example, a Social Security number. So any other circumstance that is not preempted by federal law, landlords in the state of Oregon, including landlords that are accepting Section 8 vouchers. So just because you have a form of federal assistance doesn't mean that you are in a position to ask those questions. A tenant may have to satisfy some of those requirements if they are trying to get access to a voucher, but once they have a voucher, the landlord is not allowed to treat that person differently or ask different questions of those applicants. One other quick thing that I'll add is that we ended up in the legislative discussion having to negotiate this particular language and this list of forms of identification that can be required. And the way that we had to negotiate this was to make it clear that landlords could ask for a combination of these forms as necessary to verify name, date of birth, and physical appearance or photo. And that's because some of these forms of identification don't automatically always come with photos. And so the landlord is allowed to ask, ask for a combination so that they can verify the person in front of them with the identification is in fact the person who is identified in the card just by looking at the photo. Thanks.
Yeah. And then as included, and I think actually we have, to the example that even Sybil listed, prior to SB 599, there were cases of landlords threatening to disclose or retaliate against tenants with disclosure of their immigration status. But specifically, this labels and names that a landlord cannot continue to do so and will face, potential violations, enforcement violations in the events that it happens. We'll speak a little bit more in this presentation later on about what do those enforcement mechanisms look like for SB 599 and kind of the role of legal service providers and organizations into ensuring that we uphold this. I know there's an example even recently in Illinois where this case happened. I'm wondering, do you have more information to share? I know you had an example.
Yeah. So this is an example that we read about that took place after passage of Illinois state statute, and there was a prosecution or an enforcement action against a landlord specifically for this exact case in which there had been a request for repairs. The tenant had withheld rent because the repairs that they had requested, which were not followed through with, were so significant that they were impacting, the value of the space. There was a lot of unusable space. and the landlords were threatening to call ICE, and it was a family that did not, that had a fear of potential ramifications in that circumstance. And there was an action brought, and there was a civil penalty assessed against the landlord because of their violation. And so certainly we trust and hope and assume that this will not be practiced, but it is important. We want to make sure to let people know that there are ramifications for violation, and that's the intent, is to protect against that kind of threatening behavior so that people can be safe in their homes. Sure. So I'll talk a little bit about the remedies for violation. And as Hannah mentioned, we had initially drafted this bill to put immigration status as a protected class into the Fair Housing Act. And that would provide broader protection in many more circumstances than just rental housing. Our state Fair Housing Act applies to lending practices, to real estate practices, to home ownership, to renter rights, and other circumstances. And ideally, ultimately, that's where we would like to get. We ran into trouble in terms of opposition as well as drafting problems with the Legislative Council, who were wonderful in helping us find the right language here. But there are all sorts of federal mortgage programs that have very differing kinds of immigration status requirements that also would have had an impact on some of the state agency lending programs, and we could not figure out how to thread that needle in a way that would provide the protection that we wanted without triggering concerns about the those lending programs. And so that remains a pin on the whiteboard for us to continue working on, but we didn't want to let that complexity hold up this really important protection. So we decided to amend the Landlord-Tenant Act instead to provide the exact same protections, but in the context of that statute. And so there's a little bit of a, is it a technical term to say, like, it's a little wonky in the way that it's drafted, but what it does is explicitly state that the remedies for a person, if there has been a violation of these protections, are intended to be the exact same, no more, no less, as there would have been if they had been a violation of the Fair Housing Act. And so we cite two provisions in the Fair Housing Act that are the remedy provisions, and we also cite to the anti-discrimination section of the Landlord-Tenant Act to make it clear that they should have the same assessment and the same remedies. And so, number one, there is a defense to an adverse action, which is basically mostly another way of saying it's a defense to eviction. If a landlord is trying to evict and it's because of this reason, that's a defense to eviction. You win the eviction. But also you can seek proactively injunctive relief and equitable relief. Injunctive relief is another way of saying you got to stop this behavior. And equitable relief is another way of saying, essentially, whatever the court thinks is fair to address the circumstances that are happening, because we recognize we won't be able to crystallize all of the different examples and forms of potential violation. It's a way to have sort of flexibility. So those are two really important provisions. Also, compensatory damages. I'll go through this list and then come back for questions. Thanks. Compensatory damages or $200, whichever is greater. $200 is not a very big sum of money, as we know, but it's important to have an amount in the statute so that you can be compensated even if you didn't actually lose money. And it's another way of helping the court to determine who is the winner in a court case. Also wanted to flag that in egregious cases or in pattern or practice cases, in other words, where someone is a multiple violator or a repeat violator, there is the ability for the Attorney General to step in and provide more consequential damages as a way of addressing how the seriousness of the behavior. So maybe we should stop and just take a couple questions, and I know there's one.
No, my question, I kind of missed the equitable relief part. Could you repeat that part again?
I mean, I think a more sort of plain, I'm not the expert on equitable relief, so I'll give that as a caveat. But I think that the way I think about it is it's essentially a way of saying flexible relief that is in the court's discretion. So the court can kind of say, hearing what I hear from you in this crazy set of circumstances that may not look like any other set of circumstances I've ever seen, the court can sort of take from that and try to respond in a flexible way that gives them the discretion to address the harm that has happened. So I think it's kind of a way of flagging, like, as the legislature and as a lobbyist, I'm not going to be able to think ahead of time of all the ways or all the possibilities. So we'll just put this little flexible piece in there that says the judge who hears the facts can decide, if that makes sense.
So if folks have questions, you need to use the microphone. This is getting recorded. It'll be put on YouTube in a couple months, but we want to make sure any audience that watches has access to questions being asked.
Thank you.
For the record, I didn't know about the YouTube part.
Yeah.
Yeah. Sorry, go ahead.
Well, I'm also writing notes, so sorry, I'm kind of like asking the same questions. And for the adverse action, could you repeat that part one more time as well?
Oh, the first bullet refers to defense to an adverse action. And so that basically means the tenant can use the fact that a particular set of circumstances was a violation of Senate Bill 599 as a way to defend themselves against an action that a landlord might be bringing against them. Most commonly in this situation that I can think of, it would be in a defense to an eviction. So if a tenant is being evicted in a way that is retaliatory or discriminatory, they can use the fact that it is a violation of Senate Bill 599 to discriminate on the basis of immigration or citizenship status as a way to defend themselves from that eviction action and keep their housing. Okay, maybe we'll move through and we'll build some more pauses in for other questions as we go. So this is one additional section that I'll cover briefly, and happy to answer any questions about it. So another piece that I wanted to really flag is that the Senate Bill 599 protections cover two types of discrimination, and we are lucky in the state of Oregon that our Fair Housing Act is enforced to cover these two different types of discrimination. And one, disparate treatment, is the kind of discrimination that we mostly think about when we think about discrimination. It's overt, it's explicit. For example, I don't rent to someone who is not a citizen. That is overt disparate treatment, direct discrimination that is clearly banned by Senate Bill 599. But disparate impact discrimination is also covered. And what that means is when there's a facially neutral policy, for example, it's not talking about immigration status or citizenship status, but maybe there's a rule that says English speakers only may apply. And that is something that would clearly have a disparate adverse impact on people with certain immigration or citizenship statuses. And so the coverage of the bill is more than just direct discrimination. It also covers disparate impact if the neutral policy has a disparate impact on people based on their immigration status or their citizenship status. Happy to answer questions about that if anybody has any, or happy to chat afterwards. But we're very happy about that piece, so thanks.
And then just to kind of cover our bases, we've talked a lot about what does SB 599 do, right? In terms of the different forms of identification that a tenant could utilize to prove, their identity and to be able to rent, as well as kind of the protection against threats of disclosure, and also the fact that it covers both, something you mentioned, but, real or perceived immigration status. But we want to be clear also about what it does not do, just for the sake, because we want to make sure our folks are really empowered to know what their rights are, and that they know when to go to folks, that they know when to go to legal service providers, to go to community-based organizations and tenant advocacy orgs. And so it doesn't specifically protect against, in the events of neighbors potentially disclosing their immigration status to federal agencies, or specifically protect against the presence of ICE in their apartment complexes or in their housing units and spaces. What we are going to also talk about is what do housing providers and what do community organizations need to know about ICE presence in their apartment complexes to really be empowered with creating as much of a, I would say, a barrier and stopgap in time for immigrant and refugee communities in these spaces. Because we realize our frontline communities are, getting bombarded and also overwhelmed with an ICE presence, and we realize we must equip each other with the rights of knowing what we must ask of ICE and what we must know of their presence in order to protect our folks. Yeah.
So in the previous slide, you said that it doesn't require the Social Security. How would the landlords check credit if no Social Security is requested?
I love this question. Thank you. It's very easy. It can be a little more difficult. It's like the clearest and easiest way to use a credit check agency or a criminal background check is to plug a Social Security number in. But I think that, and there's a whole document which I will upload into the materials called Myth Busting, Screening Tenant and Applicants Without Social Security Numbers. And it goes through a bunch of different questions that many housing providers have about how to do that. And so a couple of things. One is date of birth and address are good data points to use and will get at basically the same information. It may not be as exact, but it is I think the recommended step to take, and that is something that you can verify and prove from your list of approved identification documents under the bill. When we asked landlord associations and housing providers about the bill as we move forward, and I should flag, thank you so much to Housing Oregon, because Brian and Christina and Kevin all really helped us a lot with the drafting of this bill and also with testimony and everything else. So we feel lucky in Oregon to be supported by housing providers in this bill, and many of the private housing providers also supported the bill. So that was great. But I think what they said is that they already trained their folks not to require a Social Security number because they don't want to risk violation of the state or federal Fair Housing Acts, and they provide training where they can to folks who are their members about how to do those credit checks and those criminal history checks without that number. And so I'm not a background check expert, so I'm probably not the right person to ask for the best training, but the point is that both of those requests, both of those searches can be done without the use of a Social Security number, and it is was best practice even prior to passage of Senate Bill 599 in order not to risk violations of the Fair Housing Act. So I think that's the most complete answer I can get, but I will also upload this document into the materials so you can check it out further. I see we have one more.
I'll also say so I'm Shail Reuter. I'm the Education Outreach Director at the Fair Housing Council of Oregon, so we've had lots of talks about this. When I am teaching trainings, and this also comes up around credit history, really like what landlords are looking for is they're actually looking for, is a person reliable to pay rent? And you don't need a Social Security number to figure that out. You actually just need their rental history, their date of birth, their name, and you run that rental history, and then you can actually see, are they reliable about paying rent?
I see here it says that this does not stop neighbors from threatening to disclose. I'm wondering if there's any liability potentially on a landlord if they have policies that would not have them preventing neighbors if this is their own tenant. So if other tenants are harassing or threatening their neighbors and the landlord has no policies against it, or they refuse to do anything when the tenant complains about that harassment, would the landlord potentially have any liability under this? Or is it, I see the language that you gave was that the landlord themselves cannot engage in that kind of harassment. So is there any indirect liability by harassment of their own tenants?
I think it's a great question, and it's a question that I would be asking myself if I were a landlord. And I think best practice would be to have policies in place that prohibit discrimination, tenant-on-tenant harassment, and discrimination, and that ought to apply to any kind of harassment or discrimination that is protected by law. So against someone on the basis of race or national origin or immigration status or any of the other forms. So I do think best practice is that those policies should be in place and that they should be enforced uniformly. Shail, I don't know if you have anything to add to that. Thanks.
I actually do. Stephen and I had a fair housing session on acts of hate and harassment and landlord responsibility. So even if a landlord doesn't have a policy specifically around acts of hate or harassment, if one neighbor is harassing another neighbor and it is based on national origin, like I'm going to threaten, I'm threatening, I'm going to call ICE, all of those things. Once that neighbor that is experiencing the harassment discloses it to the landlord, to say, hey, this is happening, as long as it's the same landlord over both tenants, that landlord has a responsibility to be protective of the victim's fair housing rights, regardless of if there's a policy in place or not. We always say it's advisable for them to have a policy because it makes it easier for them to fall back on something. But even if there's not a policy in place, it doesn't mean that a neighbor is allowed to harass another neighbor based on protected class. The guidance that came out, it came out from HUD in 2016 around that specifically.
Thank you for that, Shail. I think it's enlightening, to know about what are, because, I mean, on top of this, SB 599 as a policy, we know we're always trying to expand what are the ways that we can have wraparound policies to better enforce it. What are the ways that we can indirectly enforce it through community education? And so, as I brought up earlier, as kind of Shail is here, has indicated, Fair Housing Oregon, or Fair Housing Council of Oregon, excuse me, is the space that you would report that kind of discrimination being experienced. And that's kind of the strongest, that is the legally enforced mechanism. And so as we've kind of included here, and folks will have access to the presentation to these bullet points, but in any form, whether it's, if you've been in a car accident, whatever, it kind of harassment, workplace, all of it is kind of rooted in make sure you document everything happening. Take record of everything going on. Take photos, whatever is needed to prove that there is this disparity in treatment, and that you can show as much as possible the story that it is rooted in your immigration status, folks that you work with, and get the names of any neighbors that you also that might be experiencing the same thing or have witnessed you experiencing this. And then I know, Shail, if you want to touch any more about that enforcement mechanism, but there's a direct form on the Fair Housing Council of Oregon website where you can upload and share a little bit about the information, and I know someone will contact. If you want to I don't know if you want to share a little bit more about the experience briefly, but.
Well, I would like to pass it off to our legal director, because that's his department.
Hi, yeah, so me or one of my team members is going to end up reading that submission. So I will just, I like to manage expectations with FHCO. We are a relatively small nonprofit. Our intake and enforcement team is 3 people, 4 if you count me. So, and not my entire work duty is enforcement work. I also have some administrative duties. So I just want to manage your expectations, because if you do submit a complaint to us, you might not get a response right away. And that's because we're working through about a month of backlogs at any given time. And so we are getting to your complaint, but I just want to let you know that once we receive that complaint, it'll wait at the top of our inbox for a little while we work our way up to it. When we get to it, we'll vet it to actually see if it makes an allegation of housing discrimination. We get all kinds of complaints. We get employment discrimination complaints. We get landlord-tenant complaints. We get complaints against cities. But we only handle fair housing complaints. So we actually have to vet the complaints to see which ones are within our wheelhouse, within our jurisdiction. Then once we have made sure that there is actually a fair housing issue there, we will contact the complainant. We receive complaints from both housing consumers, and we receive a lot from caseworkers, community partners, public housing authorities. We receive complaints from all different sorts. So, but we will ask to be put into contact with the person that experienced the discrimination, so that we can interview them, talk to them about, who saw this happen, did any of this occur in writing? Did you email with your landlord about this? So that we can start building evidence for a case. And then what enforcement looks like for us, we are not a government agency, we're not a law firm, so what we do is we help people file a complaint with the government agency. At this point, it's usually Bureau of Labor and Industries because HUD is, well, it's part of the federal government and it's doing about as well as the rest of the federal government. So we focus on BOLI at this point. We do help people shepherd their complaints through the BOLI process. On occasion, we might decide that BOLI is not the right venue. We'll try to get someone paired with an attorney to go straight to court with it. Or alternatively, if we don't get the result we want in BOLI, then we might go to court after that, because not getting the result you want in BOLI is not a reason to go to court and get a better result, because you have more time, resources, and control over the case. But so that's what enforcement would look like at Fair Housing Council. So I'm sorry for taking too much time to explain that, but hopefully it was informative.
I'll also add on to that, our hotline, we speak English and Spanish in-house, and then we use interpretation services for languages outside of those needs. People do not have to income qualify. Of course, people do not have to have, citizen documentation to, receive our services as well. And we also work from a trauma-informed practice model as well. Easiest way to report possible discrimination to us is fhco.org. There's a big pink button at the top of our website. It's obnoxious. You cannot miss it. So fhco.org, and the button says report housing discrimination. So we try to make it as obvious as possible. And that website also can be translated into other languages as well. We have a button for that. So if somebody's not an English speaker, we try to make that accessible. Oh wait, this is my microphone.
And it looks like, we have one more question.
So for the part where it says record all documents, I don't see, but sometimes when I work with people that I work with or collaborate with, clients, I do tell them to, I don't know if this is helpful or not, but I do tell them to seek a therapist. If a therapist does count as documentation, I just because I don't see it up there, does that count? Yeah.
There are myriad reasons why someone experiencing discrimination might want to see a therapist. First of all, it's traumatic. But second of all, it doesn't hurt to have someone qualified to speak towards your mental health in a legal case if we're going to end up talking about the damage it's done to you emotionally. I'm sure if you've watched courtroom dramas or if you've been in court, you might have even heard someone throw around the terms like intentional infliction of emotional distress. If someone's going to make those types of claims, then yes, it is great to tell them to start talking to a therapist so that they have a mental health professional that can competently speak to the mental distress that they've talked to. So yes, I think that's actually a great thing to advise people. I try to do it gently because not everyone likes to be told, you need help. But if you couch it in the right terms, then people can be receptive.
I guess my question is, does that count as documentation?
Okay, wait. Do you mean, does it count as documentation as far as identity documentation, or documentation if there's a possible claim of housing discrimination? Yeah, what Stephen is saying is it could. It can help to build the case around the emotional distress that's caused by a situation. Yeah.
And I think that's also a great point to bring up in terms of the myriad of ways that we can create the documentation, right? Because it all comes with the asterisks of it possibly could be helpful. The point is we want to collect as much of the information as we can to see what is viable to prove that there is discrimination happening. And so this is also where I love to interject and say, as this is always top priority, fill out the report form, fill out the submission. And also in the midst of it, it's okay to seek legal service providers and advocacy organizations to help you with the process, to help you collect the information that you need. I'll make sure that we upload the information as well. But for example, at Unite Oregon, we have a housing referral program we don't dole out specific service or legal service or rent assistance, but for folks that are trying to figure out the process, because it can be really overwhelming, especially if you're going through a traumatic situation such as potential eviction or discrimination, you can come to us and we'll walk and sit you through the process to see what do you need to gather, who can you go to, and how can we apply together. So I think that it brings up an excellent point of who else can be a wraparound support to help you go through this process. And I think, so as we mentioned right now, because, well, actually we didn't include, but as I said earlier, at least for Unite Oregon, this issue around discrimination regarding immigration status came up to us around 2020. So actually before the current political moment that we are in right now with the mass expansion of ICE. And so it just ended up being, I guess, something of a timely presence that this bill was getting passed in the midst of this federal administration. So we do want to kind of provide some information around how does this bill interact with ICE presence. I want to, if you want to share more about that, Sybil.
Sure. Thanks so much. So I think maybe as a caveat before we dive into this slide, I would say that this particular set of issues is worth its own training. And there's a lot to be said about each of these bullet points and more. And the Law Center has worked with Housing Oregon in the past to provide detailed training. We are working on updating that because the situation is evolving rapidly, as we all know. And so when those materials are updated, we will share that back out with Housing Oregon for further dissemination, and we're always happy to help people get access to information as well. But I also want to make sure, and I don't know how many of you here are housing providers or in touch with people who are housing providers, but the National Apartment Association actually has some pretty good materials on their website that were developed earlier this year because they were getting a lot of questions nationally from their members, whether their members were private landlords or public housing authorities or other agencies. And so they developed some resources that I put the link to that here in these materials, and I would encourage folks to check those out. But there are a couple of key bullet points that I just wanted to highlight. And number one is getting training like this about what the Fair Housing Act requires, what Senate Bill 599 requires, and how those requirements differ for private landlords compared to public agencies. Public agencies, such as housing authorities, must understand Oregon's State Sanctuary Protection Act. That has been in place for a very long time, and so most public housing authorities as agencies have been receiving training about the Sanctuary Protection Act for some time. However, things are getting more complex as the federal administration's interactions have changed and morphed very rapidly over time. And so the level of interaction with those questions is escalating, and I would encourage folks to get training on the Sanctuary Protection Act as quickly as possible. And the Sanctuary Protection Act goes further than Senate Bill 599 does in terms of what kinds of information can be shared with anybody. And so that brings me to the next point, which is that it's important that landlords know the difference between administrative warrants and subpoenas and orders that are signed by a federal or state court judge. And those can be hard to tell the difference, and it's important to get training on what the difference is. But for the purposes of today's presentation, what I'll say is if a warrant or a subpoena has been issued by a federal judge or by a state court judge, so in other words, the documents are labeled as having come from the authority of a court, they are very difficult to get out of, and the bottom line rule is that they must be complied with. If they are administrative documents, in other words, they were signed by an individual who's citing ICE requirements or ICE statutes as their authority, or they're signed by an agency or someone who's coming from an agency, they do not have the same force of law, and they can be contested, and they ought to be contested to the fullest extent in order to protect tenant privacy, honor civil rights, and make sure that to be in compliance with the law. So along those lines, it's important to have written policies that will help landlords and help property managers understand what the rules are. It will also help tenants and tenant communities understand what the rules are. And that both protects tenant privacy but also ensures legal compliance. And we are happy with other partners to help provide training along those lines. Another thing that's really important that everybody should have information about is how to verify and consult. So if someone is coming to an office, for example, and asking for information about immigration status, and they have documents in hand that they say entitles them to that information, you want to verify who that person is, who do they work for, what kind of identification can they provide to you. Look at the paperwork and identify whether it is coming from a court or coming from an agency. And the bottom line is you are best if you consult with counsel before doing anything. That ought to be the primary response. And then lastly, I would say that education for staff is critical here, and also making sure to educate your tenant communities and your neighbors and yourselves, and we advise that landlords ought to provide resources for tenants, because many tenants will have questions about what their rights are, what they can do to help best protect their neighbors, and having those conversations and getting that information out to the community is extremely helpful if it's done in advance and not in the midst of a crisis. So I think those are the things that I would offer. I don't know if you want to add anything, Hannah.
I mean, I think in terms of just really emphasizing kind of the role of the tenant-facing organizations, and it really is just to build off the importance of educating folks who are tenants. And I say tenant-facing because this is not just our tenant associations. This is, I mean, when 4 out of every 10 Oregonians are renters, all of us are tenant-facing organizations. And so I mention this because the fact of the matter is, with many of our immigrant and refugee communities, many of them don't believe they have rights right now, or that they are accessible, or that they can be protected in any way. And what we're here to show up and say is that the law, the way that SB 599 can be used, it's a legal shield, right? It is something, especially in Oregon, that we can utilize to protect someone's stability and someone's housing and stay here. And so the role we have is to make sure that we are renewing and that we are updating our Know Your Rights workshops, especially geared specifically towards housing, and how can we ensure that folks know they do absolutely have the power and the right to stay in their housing, and also to not be harassed or retaliated against. I think that's especially an important piece because we have faced many stories of immigrant and refugee communities who experience either these livability conditions or high rent increases that they feel like they don't have the space or right to speak out against. And so how can we show up and say, actually, you are empowered by your rights? And not only that, how can we show up alongside with them to advocate for their conditions? And so that is really some of the roles that we can, step up and provide, as well as advocacy. I think we mentioned earlier around how can we make sure there's good policies in place for housing providers? How are we working alongside folks to making sure that they have received training, that everything is incredibly explicit to ensure that compliance. And the role of organizations is how can we step up in that role to bridge that communication between tenants and housing providers to create as much of stability as possible for our communities right now.
Thanks. No, that's great. Thank you. I think we have one more question. And while the mic is headed that way, I'll just say this is a list of some of the resources. And Shail, you mentioned the fhco.org website for filing fair housing complaints. We also have the Oregon State Bar Legal Information and Referral website, and that includes information about where to find free legal assistance for low-income Oregonians. That would include my organization, the Oregon Law Center. That is a place where people can get legal information and advice. We all work together and refer to one another. So, for example, if we have a case that comes through that we think the Fair Housing Council ought to know about, we'll be reaching out, and vice versa. Also, the Bureau of Labor and Industries, as Stephen mentioned, does have an enforcement role to play. And to Hannah's point, the Springfield Eugene Tenant Association and the Community Alliance of Tenants are two of the state tenant associations that provide free assistance and advocacy and can help someone talk through what choices are best for them in a given circumstance. All of these entities have less funding than they need, and we are always advocating to provide more funding for those organizations so that they have more staff and can be more helpful as calls come in. And that remains a consistent goal as we head into tough budgeting situations. But I know you had a question.
Yeah, my question, just a clarifying question. Um, it rent increase can be seen as like a, well, I mean, depending on the nuance, can be used as a form of retaliation.
Absolutely. So I think the question was, could a rent increase be an example of retaliation or discrimination? And I think the answer is yes. It would depend on the facts of the circumstance. So if you're raising a person's rent based on their immigration status or based on their citizenship status, that would be a violation if you weren't raising everyone else's rent to the same extent. And so that's about, is it disparate treatment? Or is there disparate impact? So you go back to, is this a rule that is applicable to somebody or being enforced specifically because of or related to someone's immigration status? Or does it have a disparate adverse impact on a person because of their immigration status, even if it's not something that's explicitly about that, if that makes sense? So rent increase could fall into that. An eviction could fall into that. Refusal to make a repair could fall into that. There are many kinds of examples, and we probably couldn't come up with an exhaustive list. Okay. Excellent.
And I think additionally, so as we've mentioned, there's these resources, these organizations in place that you can be referred to who can advocate for you, or who you'd refer your cases to, who'd review them and kind of see whether there is cause or not. Want to make sure that also that folks know there's plentiful resources, whether through these organizations or even online, about what your rights are for tenants and families. I would say, I think there was, with the initial of this administration, a lot of know your rights workshops, and with kind of the initial of this administration. And what we want to emphasize for folks is that these can be and should be renewed, updated as information continues to get updated, and that it's really not just a one-time thing, but folks need to be, folks need the continuous education, I think, to know how their rights are being affected, and how they can protect them, to know what they are. And so we'll make sure these resources are uploaded. These are two that kind of lets folks know what is their rights as tenants and how their families can also be prepared in these situations of emergencies. I think we have a question. Yeah.
My last question. I don't know really how to articulate this, but I know that as the topic on refugees, I have personally seen, not so much with refugees, but with other culturally specific programs or housing programs, the topic of double dipping in funds. Personally, I have not come across that with refugees, but I don't know if in your experience, you have had experiences with double dipping in funding, and how that would, if that has come to be in a way of like harassment or discrimination, or I think it's called I forget what the word is. Disparate. Yeah.
I'll say a couple things, but I see Stephen also raising his hand. And so I think one thing to say, if I understand your question correctly, is, I think part of this bill's purpose is to make sure that landlords and housing providers are not in the role of meddling in things that don't involve them, and so it's irrelevant to a landlord whether or not someone is a citizen of one country or another, or what their immigration status is. What's relevant to a landlord is, are they getting paid? Is the tenant a good tenant? Those kinds of analyses. The landlord doesn't have any, if the landlord is getting paid, it's not the landlord's business where it's coming from. That's a different analysis. If there's a double dipping situation, and I have not seen that. I hear a lot of people talking about that sometimes. I have never seen that in my experience, but if that were happening, that's not a landlord's business any more than it is my business. And so I think that the line that this law tries to draw is, here are the things that are within the realm of legitimate, important questions or analyses for a housing provider to make, and here are the things that are not. And so I think that's how I think about this bill. Is it's especially establishing that immigration status and citizenship status are not to be asked about or to be used as a criteria in any way in situations that impact housing. But I see Stephen had raised his hand, so I don't know if you want to add anything.
Yeah, it was kind of a reaction because I wanted to see if I understood the question. But do you mean the landlord is double dipping, like charging like a housing authority and the tenant again, or is this that's what's happening? Or
So I guess to kind of clarify, so I was not directly involved, but I had a friend who she had a neighbor who it was a culturally specific program. I can't say because they're going through the court system, and so sat down with the tenant and saw that there was double dipping. The property manager knew that there was double dipping. And so what I was thinking, I was like, oh, if I were to be from another place and I don't know English and I'm not very well versed in my rights, that can be easily be taken advantage of. And so I guess that's where I was coming from. Me personally, like being an immigrant and English being my second language, I just want to know like what my rights are, and if there's, I don't know, just a multitude of things that just came about in my head about just fair housing. So I would love to say more, but I just know that it's going through the court system. But in my head, I was like, oh wow, if I was a refugee, like I just wouldn't know. Yeah, sorry, I probably doesn't clarify much, but.
I think it does. So like if I understand the situation correctly, and I can't provide legal advice anyway in this context, so it's okay that you can't provide me with specifics about the case. But this bill and other fair housing laws as well, for that matter, would prevent a landlord from going to a tenant and saying, you know what, I know you already paid your rent this month, but I really need you to pay another $400 if you don't want to get evicted. And I have heard stories, actually just this weekend, from people that like to come and talk to us about this kind of stuff because of who we are, of refugee communities especially who are targeted by this practice for the reasons you described, because they feel less secure, because they feel like the safest thing to do is doing what's demanded of them so that they'll leave them alone. But obviously people that do that kind of thing, they just come back for more, so it doesn't really provide them with safety. But yes, if this kind of practice is targeting a refugee community specifically, absolutely, 100% I would say that that's a fair housing case, and I would love to hear about it at Fair Housing Council. I would love for us to know that it's happening.
And with that concludes our workshop for today, which we want to leave time for. I think we have like 15 minutes and want to leave kind of opportunity for questions from y'all. But yeah, I think just to the point, Stephen, you mentioned of the treatment, I think a lot of immigrants and refugee community are feeling right now in terms of, I just maybe need to be listened to what I'm being told, and maybe there's not really an avenue for me. And I think this is really where our power comes from right now. How can we implement the mass education for folks to know what are their rights, and how can we be in solidarity with them to make sure those are being protected and upheld right now? And I think that's really wanting to see that there is an ecosystem of different organizations of at Unite Oregon, Oregon Law Center, Fair Housing Council of Oregon, to see how can we all work together as a team to make sure folks are protected right now. And this is just one avenue, and I hope folks are able to take it as such. But I want to open it up to see if there are questions for about the workshop. Fair Housing Council of Oregon folks, I know you're so intimately aware of this, if there's angles and dimensions that you want to share about as well. But I'll pause there.
I just want to ask if there's any, like, you had mentioned that it's good to get some more training, especially like around the ICE situations right now. Like, do you guys offer those trainings? Like, where could we find those trainings?
So, thank you so much. There is a training that we have a recording of that the Law Center did with Housing Oregon back in the spring. And I think that's a good starting place. Also, but we are working on updating materials so that we can provide more in the future. The other thing, I think Oregon for All spoke at the panel yesterday and said that they have Know Your Rights trainings. I think those are geared more towards tenants and individuals than possibly to landlords or housing providers. And so I think, I've noted that that's something I want to explore further. So I guess the other thing is, as a housing provider, maybe it kind of depends on what the specific population is that you're trying to provide education for. But I do think that the National Apartment Association had really good materials on their website. I think that's another good resource for housing providers to take a look at. It's not explicit legal advice, but it does have very good bullet points about all the things that providers should be, should have policies on or should have training on. So I think that's a good starting point as well. Thanks for the question.
I'll also say the Fair Housing Council of
Oh, of
Oregon
course.
offers
How could I
trainings
forget?
about fair housing law, and we can include information on Senate Bill 599 as well with that.
I'm embarrassed that you had to say that, Shal. Thank you.
Yeah, I just want to say thank you guys for all the work that you guys did on this bill. But one of the things that I was curious is, like, when did this pass? And specifically, I know you guys are trying to spread the word. And I work in a housing program, and I'm a little disappointed that I'm hoping that it passed recently and that you guys are just going, you're barely starting your communication strategies. But I'm just curious because if it passed a while ago and I'm barely learning of this, there's a huge gap right there because there's a lot of people that are serving our communities that this information would be super valuable for.
I appreciate the question. So in terms of when its passage happened, it was regarding this last legislative session, so 2025, and especially was enacted into law June 27th. So fairly recent, but that does mean we still have a ways to go into making sure that we are communicating this. As kind of through the Stable Homes Coalition and Unite Oregon, we've created a communications toolkit, which will be uploaded and can be shared out, and which we're intending is for any organizations who are working with immigrant populations, tenant facing, really whoever. We have information already cut and paste blurbs that you can include to get the information education out. So we'll make sure definitely to get that and to share with any colleagues as well in housing programs. But I appreciate the question of how can we communicate this?
Yeah, and one thing I'll say is, we're in the community doing education with consumers, advocates, and also housing providers. And this is so new that housing providers are still sort of figuring out how do they implement it. But sort of informally, what we've heard from background companies is it doesn't actually change how background companies would screen, because they can screen without, official citizenship documentation for the United States. So for background companies, it's not a problem. It's just really housing providers understanding they need to start changing their screening policies. But I think that implementation, it's going to take just maybe a few months for them to figure out.
We really appreciate the opportunity to shout it from the rooftops here, and thanks. The social media tiles that Unite created are brilliant and in multiple languages. So we will make sure that those get to the audience members, and please use them however you can, or let us know if you want to see something that you don't, because happy to try to create additional pieces.
All right. right, and I believe that you will get emailed some evaluations for the different sessions that you attended. Housing Oregon really hopes that you fill those out. Also, as somebody who has presented here, I do hope also you fill those out. All of the presenters really appreciate feedback on the sessions. Thanks everybody for attending this session, and thanks for coming to the conference. Congratulations, you finished day 2. Have a great afternoon.